Hey guys, we are going to watch the Stefon Diggs trial. The court currently has, I'll let you hear it a little bit, the white noise machine running. So that's why I have it muted. Because I can try to make it real quiet. There is a case background in the description. We'll go through it right now since we're waiting for this to start. Hopefully anyone that comes in late just clicks over to that description and checks it out. But there's a few legal matters surrounding Stefon Diggs right now. It's been interesting to follow. This is a criminal case. This is a criminal case where he is facing felony assault, felony strangulation, and misdemeanor assault charges. So very serious charges. The story stems back from something that happened at the beginning of December last year, where his personal chef alleges he slapped her across the face and then tried to choke her by putting like his arm around her neck with a dispute over pay. So even though it's a criminal case where the opposing party will be the government, it'll be the Commonwealth. This is in Dedham, Massachusetts. It's still a case where a lot is going to hinge on the complaining witness for the testimony. Likewise, who knows if we'll see Stefon Diggs take the stand in his own defense. His attorney here is Mitchell Schuster. Kind of a big shot attorney, but that's not surprising. With this case today, we're going to get to see some jury selection questions, which I think is super cool. They're going to be impaneling a 6-person jury, not 12, but I imagine there will be some alternates. And I don't imagine this trial would run very long, couple days maybe. But other than that, you know, I know the background on the case. I don't think I'll know anything more than what we'll hear when we get to opening statements, so I'm sort of like a clean slate on this one, and I'll be watching this one almost like a juror. So let's see who's in the building bright and early. This was an unplanned stream because I didn't know if there'd be a feed. So hey to everybody. Got everybody popping in here. I dropped some gifts off too for the early birds. Thank you guys for being here early. Good to see everybody. And let me know, have you heard about this case? Have you been following along with it, or are you just in it because it's a new trial? Yeah, 6-person jury, what in the Florida? I think that's not always uncommon. Not always uncommon. You know, similar cases like this that I followed have been 6-person jury panels. Got a nice watch there, nice and green. I know a detective who might like that. And let's see, I do have captions turned on in my own video. You'll have to toggle them yourself. But I don't see captions on this feed, so I can't put them on screen while we watch live. Martina says, I'm in it because Kat went live. Love it, love it, love it. Steven says it's a he said, she said case. And what I think is going to be crazy with cases like this, if you've never followed one before, like, the prosecution, in my opinion, with cases like these, I think they can overdo it. And we'll see what this team does. I don't know this prosecution team. But sometimes in cases like this, they go so over the top with the dramatics that it kind of waters down what the claims actually are. And I don't really think that that's always a good strategy, because if you say all of this stuff in the beginning and you make it such a dramatic thing, and the defense is able to say like, well, it was just like this tiny little thing that happened and it's being misunderstood, I think you kind of lose the jury a little bit there. So I would like to just see both sides play it straight. Let's see, everybody popping in. Hey, hey. Yeah, OG Cappy says, I thought it was judged by 12. Certain, depending on the jurisdiction and the nature of the charges, I mean, typically, like, if you're going away for life, you'll probably have a jury of 12. Sunshine for you here with the reminder to hit that like button. That would be awesome, guys. I hear the whispers. The white noise machine isn't very good. And we have it low. If we have an extended break, we can watch the final hearing. There was like a hearing 2 days ago that was about 40 minutes long. So we can watch that, check out some, you know, outside the jury presence stuff before trial started. I wish we could see his face so we could try to lip read. I agree. Mama Weezer says this is a treat having this streamed. I agree, especially since we're going to hear jury selection questions. You know, a lot of trials that are streamed live, they'll start with opening statements, and you don't get to see that process. But I think it's cool to see how a jury is impaneled, how a jury is deselected from the pool and whittled down to the 6. Yeah, Tatum says, move your head, lawyer. Come on, Mitchell. I don't know the judge's name yet, Karen. Some cases, you know, before they start, I've gone like knee deep into the docket and the motions. This one I kind of just only know the background based on what's been reported. It's not like a docket deep dive case for me. But I'm sure we'll hear or see the name tag. Yeah, the braids are super fresh. Hey, Lexi the Law Nerd. If you guys don't already know Lexi the Law Nerd, like the queen of daily trial recaps. And that's not to put her on the spot to say she's doing recaps for this trial. But the trials that she does coverage of, her recaps are incredibly detailed. So let me drop her link over on X. Here's Lexi. Oh, I think we're starting. We're going to get a hear ye. His attorney, David Kennedy. Nice, Brooklyn. Nice, Brooklyn. So who here is, this isn't your first Massachusetts case. Who else has watched a Massachusetts case before? Everyone dressed really nice. This is the criminal case. So he's got some civil matters to deal with, which we can follow those too. If they, you know, if they make it all the way to a trial, and sometimes they don't. Law Nerd Amber says, hear ye, activates me like coffee. We're gonna have a clock in this trial, guys. I don't know if we'll get a fan. It's a nice clock. You can get some reflection, see what's going on a little bit. Yeah, everybody raising their hand for the Massachusetts trial. We are gathered here again. Mofka, someone break Mofka's record. It says, I've seen about 20 in Norfolk. And is it Norfolk or Norfolk? Yeah, I'm a New Yorker, so like we always said Suffolk County, and then hearing the way that some people say the same thing in Massachusetts, I was like, what? And then I realized it's two totally different areas. Uh, Jen, I think you are in luck. I don't think we have any Canoni. Canoni is over on the civil docket now. Oh, I'm hidden. Let me move. Dizzy with the correction. Should we do a poll on how to pronounce? And Dedham, I guess you could say like Dedham, 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 Dedham. Norfolk? That's a new one, I think, for me. Norfolk.
Witness.
Somebody just said witness.
Test, test, 1, 2, test, test, 1, 2, test, test, 1, 2, test, test.
They're not very good at this, blocking out the chatter. Norfolk music. Yeah, there was a little rhythm to that sound check. That was a good one. I feel like I'd feel awkward about doing a mic check. Like, should I put some pizzazz behind it? I watched a movie called Stomping Ground. I think it was Stomping Ground. It was a Sasquatch movie over the weekend. And it starts off like it's like a couple and the guy is doing like a video, like a documentary about this area that's supposed to have Bigfoot sightings, but he makes his girlfriend do the camera stuff and he's like, do a mic check, see if it works. And she's so awkward with it, she's just like, test. What do you want me to say? And I feel like that's how I would do it. It was a pretty good movie. You know, if you like B movies, which I do. They did, in fact, find Bigfoot. It didn't end well for everybody in the movie. All right, so since they have some dead time anyway, let's run through the basics again, guys. So this is supposed to be day one, I imagine. I mean, I don't think that this will necessarily take all day to do jury selection. So I wouldn't be surprised if we get to opening statements today. Maybe even a witness, depending on how long their statements are. This is Stefon Diggs' criminal trial, not any of his civil matters. This is in Dedham, Massachusetts. He's charged with felony strangulation and misdemeanor assault after an argument with his personal chef over money in December of 2025. It's going to be a 6-person jury. Mitchell Schuster is representing Stefon Diggs. It looks like he has co-counsel, so I'll have to learn their names as we go. Also got to learn which judge is presiding over the trial. Let's see. And then, if you guys don't already know, Stefon Diggs, you know, NFL player, in some relationship with Cardi B. Some people seem to know him more for that. Some people only know him for the sport. Some only know him because of Cardi B, which is two different worlds, right? But let's see, on December 2nd, 2025, so not that long ago, moving along quickly, at Stefon Diggs' home in Dedham, Massachusetts, the claims are that he and his personal chef got into an argument. By February, he's arraigned, he pled not guilty, and they just did their final pretrial hearing earlier this week. This is the allegation. This is what the chef told the police. She said, we've been texting back and forth about money, and that Diggs had owed her money for her work as a personal chef for him. She says that the conversation was making Diggs angry. So pretty sure we're going to see those text messages come out at trial, maybe even used in openings. It got into a physical, like a face-to-face confrontation, and he allegedly smacks her across the face. She says she tries to push him away and get away, but while she was trying to get away, he allegedly tried to choke her by wrapping like the crook of his elbow around her neck, like a chokehold, which I would assume, like behind. She said she had trouble breathing, which is one of the elements, right? You need to have some type of impairment of the breathing or airways, and felt like she could have blacked out. She said she had some redness on her upper chest, but didn't take any pictures. She reported this to the police 2 weeks after it happened. So, and then I do have a quote I grabbed. His attorney, Mitchell Schuster, claims that the allegations are completely false and that his client's completely innocent, and that this is all about a financial disagreement.
Here's the form, John.
All set.
All set. And we're going to bring him right in here.
Officer Rush, I'm going to be giving you that form.
Johnny.
You got stuck with this?
I know. I thought she was joking.
Danielle called me this morning and said, I don't want to do this.
I don't know.
Yeah.
I thought she was joking.
Thank you.
Yeah.
And if you're new here, I watch trials as a skeptic, with the premise that everybody's innocent until proven guilty. So can the government, can the Commonwealth here meet their burden to show that what they're accusing Stefon Diggs of, that he's guilty beyond a reasonable doubt? Oh, that'd be interesting. Steven says it's my understanding that in Massachusetts, reporting weeks later can be used against her for impeachment. Yeah, and I imagine she's going to have to testify here. I don't think this trial would be proceeding if she's not going to take the stand. Because again, she said she didn't provide pictures, like there just isn't. I don't know how else the prosecution would be able to proceed without her testimony. Lori Ball says my sister works with Robert Kraft. Oh, why did we get iced out? And she knows that he's innocent. And, I'm actually, it's been a relief, I think, generally speaking, not trying to speak on any specifics. All right, we'll have, they're back. But the idea that often when accusations like this come out, like the damage can go all the way to the extreme just from the initial reporting, especially the idea that this isn't just like a push and shove type of assault case, but the idea that somebody tried to strangle somebody, impede their airway. Like that's a very inflammatory claim. And I think it's kind of, it's been nice to see so many people say, hey, let's wait and see what actually comes out at trial. Let's see what the facts show. Let's see what actually happened here. Because while I believe that when something like that happens to somebody, hopefully the police help them out, get them to the right resources. And I don't think 100% of claims are necessarily true. So, and again, the idea that we get to watch the trial itself. There's been trials that, either you can follow through the reporting, but there's no feed. And one case that I looked at, the Jonathan Majors case, we got the trial transcripts, and the transcripts were a totally different story than what was being reported in the news outlets. Like, news outlets were leaving out text messages that said, it's just fake. But reporting on the very seemingly damning thing that followed immediately after, it's just fake. Right? So the idea that we get some transparency here, I think is also, it's the right thing. I think sunlight disinfects. Also, Grandma Ninja, thank you for being a member 13 months. Says good morning, Kat, and the chat. You guys say hey to Grandma Ninja. Grandma Ninja says hit that like button. Factual Lie also 23 months. Holy moly. That's almost 2 years. Says don't forget to do the YouTube-y things. All the YouTube things. And one thing about this trial, we will know what time it is. We will know. I'm also East Coast. I'm down in Florida, but I always think it's good. Like sometimes when we watch like a Central Time Coast and we can see a clock in the courtroom, I'm like, oh yeah. And if we continue with day 2, day 3, depending on how long this trial goes for, we'll probably start like 30 minutes late to skip this downtime. Mr. Monk's understudy says, also, because last year there was a similar attempt at a false money grab against Peppers, another Patriots player. The accuser didn't know that he recorded it, and Peppers found not guilty. There was something similar with Dalvin Cook, I think, where, you know, she sent in photos of injuries, but the story that she claimed happened, there was another person present who was recording it, and that person came out with statements in support of Cook and had a video, and like the girl ran and was threatening to get her firearm and saying she was gonna, like, I don't know if she was just gonna try to like pistol whip him with it or something, but the friend produced the video, and that was a whole mess. That was messy. It's been a few years since that, but I think she tried to go the criminal route with that, and then also a civil case, like sent a demand letter and all of that. And, like, you just never know. Like, the initial news reports, it sounds like the craziest thing, and then it kind of fizzles out when you hear, like, oh, actually, there's been a change. You know, the initial story that we all heard and reacted to, it's not really, we know it looked a little bit different now that we know more. But it's always quieter when that happens. So calling a thing says, is it just jury instructions today? I think they'll do opening statements and maybe even call a witness. I'm not sure it'd be helpful for either side to have very long openings. Like, you know. All right, Nancy New with the T says Judge Carroll seems to be on this case. Inez Style says, hey, from Shreveport. I've been to Shreveport just once. Oddly enough, during an ice storm. So, I think 2 years ago. 2 years ago. So, that was probably not the best way to experience Shreveport. The whole road was ice, just one big sheet of ice. Yeah, Stephen Fenner says Diggs is facing up to 2.5 years for the misdemeanor assault and up to 5 for the felony strangulation. If convicted, my guess is he would get some sort of suspended sentence. Yeah, and you know, sometimes when there's splits like this, if it ends up being unclear, if the jury thinks it's unclear, I mean, you've got two things you can split the baby with there, right? If the jury is like, well, maybe he slapped her, but I don't think he really tried to strangle her. You know, you're kind of giving choices to the jury. Oh, is that the safe way to say it? Being Bart Simpson? Oh, I can picture it, dang. The homered. So, yesterday my brother hit me with a thought experiment that he's like, hey, this is going viral. Have you seen the red button and the blue button thing? So I'm going to ask you guys. And I was like, this SpongeBob meme where it's like, which one do I want to press? He's like, no. He's like, it's this thought experiment, like a social experiment where there's a red button and a blue button. If you hit the red button, if you choose to hit the red button, nothing happens to you, you live. But for the blue button, if less than 50% of the population hits the blue button, anyone that picked the blue button gets Thanos. he said it like that in case I asked the chat. I'm like, that's how you gotta say it? So I was like, why wouldn't everybody... I'll let you guys answer in the chat. But I gave my answer, and he's like, right, but I guess there's people... The loud consensus on the internet is you're a bad person if you would hit the red button. And I just don't understand, because the only way something bad can happen at all is if you choose the blue button. If everybody chooses the red button, everybody lives. But if some people start choosing the blue button because they're worried somebody else won't choose the blue button, they're probably going to get Thanos. So I just didn't get... To me, it seems like an obvious choice, right? Just think about it and push the red button. But I guess there's like a shaming and a condemnation going on with this thought experiment online, where you might be a bad person if you don't choose to push the blue button. I'm pushing the red button. Because there's nothing... Everybody has the choice to press the red button. Nobody has to press the blue button. And the only way something bad can happen, the negative effect, can only come from pressing the blue button. The red button isn't the cause, isn't the direct cause of a bad thing. Kiana, wrong one. It's Cardi B. Can you imagine Nicki Minaj is there just because? Cardi B, Cardi B. She can make another album cover promotion. So let's do a poll. Let's do a poll on this. Let's see. Which button would you press? And remember, red is the one where if you push red, you're good. You will live. If you push blue, you will only live if 50% of people also press blue. So type 1 in the chat to vote for red. Type 2 in the chat to vote for blue. Let's see if anybody chooses blue. And I just couldn't comprehend it. I was like, why is this even a discussion? I felt like maybe people thought of it like a what color is George Washington's white horse type thing, where they don't really get the premise on first glance. Who do we gotta say rip to? Oh, man. Hmm. I don't know if it's gonna work out for the blue button people. We're at 88% red. And real quick, since we're on the clock anyway, if you guys like to watch walkouts, the Associated Press AP does have a live feed from outside. We're gonna watch the clock, otherwise we might miss the the actual start. Oh, yeah, what if you're colorblind? I mean, I guess vocally you'd still hear the way the question's asked. Right? We want this experiment to be fully accessible. So you'll get the proper description that blue is this, red is that, and you'll be told that this one's the red button, honestly, and this one's honestly the blue button. So... Yeah, the Julio Fulio 4 trial, the judge said they're starting late today. That's going to start at noon Eastern time. Also East Coast too. Ooh, good question. EJF is like, is there a Black Mirror episode about this social experiment, this idea? Dang, we could have watched almost the entire hearing from Friday while we waited. EJF says, Black Mirror didn't work so well for the husband. Now you can't pick shows. Uh-oh. If you guys want, I mean, we can start watching the hearing from Friday. It's like 40 minutes of actual court material. And I would keep this window open so I would hear when they're speaking and doing something. But we could start watching that hearing if you want. Sometimes when we do that, as soon as we switch over, then court starts and we switch right back. So you guys call the shots. If you guys want to do that, let me know. All right, so let me make a banner. We'll watching Friday's hearing while we wait for court. All right, guys. So again, we're going to watch Friday's hearing, the last hearing before trial, while we wait for court to start.
Here on the record, this is the matter of the Commonwealth versus Stefon Diggs.
All right. Good afternoon, ADA Drew Birchie for the Commonwealth.
Good afternoon, Your Honor. Andrew Kettlewell from Mr. Diggs.
Okay.
Good afternoon, Your Honor. Sarah Silva for Mr. Good afternoon. All right, I did see some of the motions that were filed last night. I do see now that there is a new one, a defendant's motion to exclude testimony of prior conduct. Commonwealth, have you reviewed this?
Yes, Your Honor.
I have not. So,
Understood, Judge. So we have been meeting about this in the last hour. I apologize. We ended up just filing the motion. I guess in 2 seconds.
Sure.
We went to meet with Mr. Virtue yesterday. My understanding is they prepped their witness. During that prep, the witness made statements, and Mr. Virtue then provided to us this morning in writing. One of the statements in there is essentially that in addressing the 2-week delay in report, indicates that the witness claims that she had observed a physical altercation with someone that kind of affected in her calculus. And so our motion is kind of, most importantly, just to raise it for the court, I think. In conferencing with my brother, I'm not sure if he's objecting. I believe they weren't planning on eliciting them in direct examination, but I'll allow him to speak to that.
Go ahead, Adrian.
Yes, Your Honor. As my brother recapped, around maybe 4 o'clock yesterday in a Zoom meeting with the victim and her attorney, she made a statement that she had seen a prior altercation between this defendant and some other unnamed person. I didn't inquire as to who that person was or when that was. After hours yesterday, did meet with my brother, informed him of that, and then this morning did provide a copy of the notes that the victim's advocate had prepared during that meeting and provided that to my brother. This is a situation, Your Honor, understanding a very late disclosure and a very unspecified allegation of prior bad acts. Speaking to my brother, is not planning on offering that, not offering or asking to the witness about that specifically. Your Honor, I would be objecting to the exclusion of that only in the event that the witness brings that up in response to a question about, particularly, she says she was explaining to us as to why she took long in delayed reporting, so that she had concerns for her safety.
All right, well, I have to look over the motion, counsel, and then I'm happy to rule on it.
Yes, Your Honor.
Thank you.
You did raise in one of the motions that you had filed previously, counsel, you raised, I took it at least as you're raising a concern about a possible fifth existing for the alleged victim in this matter. Is that fair to say?
Oh,
Yes, there was something in conference with the Commonwealth on March 31st and on April 1st. Yes,
Okay, so Commonwealth, you're aware of that, and my understanding is she has representation.
Yes, Your Honor, I have spoken to the witnesses.
oh, this is gonna be messy, chat. So we have a eve of trial witness. The first issue is the defense said, hey, there was really late disclosure. I respect that my brother, that's how they refer to opposing counsel here, is brother and sister. My co-counsel, my opposing counsel, it's just brother and sister. We had late disclosure from the Commonwealth last night from a witness who said that she's observed a prior altercation before. So late disclosure of prior bad acts, bad character evidence. So the defense doesn't want that to come in. Now, second issue we're getting into is the complaining witness, the chef, might plead the fifth and has counsel with her. Which, shout out to having counsel, nothing wrong with that. But this is going to be messy.
Attorney specifically about this, she asked what the perceived fifth would be. When I explained it to her, she said that she has spoken to her client about that and is still advising her client to testify.
All right,
I believe.
to sidebar for this one.
Oh, they're sidebarring. Oh my gosh. Okay, that's going to be a time. We'll try to lower the volume before this crazy machine comes on. And still no action. We're still on the clock in live court. No, they're not actually related. I'm just saying brother as a formality. Sweet Lady Sugar says, bring the messiness. Agreed, agreed. See, I'm glad. Thank you guys for wanting to watch this. How interesting. Right out the gate. Pretty quick sidebar.
All right, so now there were some other motions that were filed, and thank you for doing that. Maybe we can take care of that business this afternoon. And I am happy to step off and at least review your motion that you filed. I don't know if I'll be in a position to rule on it today, but I'm happy to just take a few minutes and see what we can accomplish so that you have a framework as you prepare your cases. Clerk, what do I have? Let's see, I have a proposed witness. I mean, I didn't pull anything out, so.
Porky's all the way in. Who else is all the way invested in this now that we hear, I am, now that we hear that the star witness, The alleged victim, the complaining witness, might plead the fifth.
Okay, there were 3 motions filed by the defense yesterday. I guess there were, one of them was, start with the easy, sequestration of witnesses.
No objection, Your Honor.
All right. Preliminary instructions. The request for model jury instruction on credibility, that was at the conclusion of the case, or are you asking me to insert?
We were asking for an insert from that. It's 2 paragraphs from page 4 to 5 that specifically go to weighing witness credibility on the what is evidence portion of the model jury instruction is to be included in part of the preliminary.
Part of the preliminary. All right, I'm not going to do that. So that is.
Okay. So
And
real
then,
quick here.
You had a
That's hilarious. You know how sometimes at some trials you'll read jury instructions before the jury, that the opening statements actually start? And then sometimes they'll have more instructions come in at the close. The defense asked for the beginning set before opening statements of jury instructions to include the model instruction on witness credibility. The instruction that usually sounds something like, you get to determine what weight to give somebody's testimony based on their credibility. You are the trier of fact. So you get to make that determination. The defense wanted to put that in the beginning as a precursor.
final instruction, I thought, as well. Was there anything as to final instructions that you had filed at all? Or was, but just so you're clear, of course, the instruction that you are proposing will be part of the final instructions that the court is giving.
Yes, sir.
Okay.
So the only other preliminary instruction we were asking for was the model instruction plus about a sentence that we added there in request number 2 in the preliminary dealing with situations where jurors might be exposed to the case outside of court hours.
I believe that in the general instructions, there is something to that effect. So give me- I think there is something. If not, I will not use the language that you have provided, and it would tend to more mirror the language about high-profile cases, and it would obviously be my intention, even if obviously this case is going to be more than a day, but to make that similar inquiry of jurors on a daily basis. Yeah. Defendant's motion to preclude the use of the word victim. Commonwealth?
No objection, Your Honor.
I like that. So they won't be able to use the word victim to
Commonwealth has
describe.
filed a motion to elicit an in-court ID of the defendant. Any issue with that?
We have no objection to that, Judge. We actually spoke about if need be stipulated to identification. I don't think it's an identification case.
Agreed. All right, so that is allowed. I did receive witness lists. Commonwealth, 2 witnesses, the alleged victim, and 1 Dedham officer, correct?
Yes, Your Honor, I filed that this morning. My brother and sister have provided me, but they also come in with a joint witness list that I have also signed.
Okay, and I have a proposed witness list for the defendant. Just so I have some frame, what is the nature of the testimony? Are any of these, quote, character witnesses? Are these witnesses as to alibi or location of the defendant at perhaps the time of these alleged text messages being exchanged, things of that kind? Just give me a little bit of
So there are, I believe, 3 of those witnesses are individuals who are at the Dedham address
Okay.
in and around that afternoon. One of those witnesses was not in Dedham on that afternoon, but was actually communicating with the Commonwealth complainant.
Okay.
Another one of those, 2 of those witnesses were outside of the state, but essentially spent the next 6 days with the complainant, the Commonwealth's witness. Witness number 6 was our phone extraction expert. And who am I missing? I'm sorry, then the only other individual, the individual from Florida, was an employee of the defendant's organization who communicated with the alleged victim in this case numerous times about her paperwork and contract situation, other issues that I think are relevant to kind of the events of the second and then the following week.
All right, Commonwealth, you are aware of all of these witnesses? Any statements have been provided to the extent that they're...
Yes, Your Honor, my brother has provided a rather lengthy report from his investigator.
Okay, and with regard to your expert witness counsel, I know that there was a stipulation in the conference report. Is there any issue? I'm assuming that your expert is talking about extractions he made on your client's phone. And is there any issue with regard to the admissibility of testimony regarding how he became came to get that phone and any chain of, or is that what the stipulation was to?
I don't believe there is any objection, Judge.
Because how's it coming in?
Which portion?
Phone. Your expert testimony that he examined a phone. Presumably it needs to be connected to your client.
Correct. There are witnesses
All right,
who
court
actually
is starting, you guys.
brought the device and other matters, and I also think that the content
We'll
actually
finish
of
this up.
the messages are the other side of the conversation is
Sure. How will the jury know that that is your client's phone, that that number belongs to your client, and that that actual phone in question, the phone itself, that your expert examined, is there any issue? That's all I'm raising. Is there any issue with that, or is are you Commonwealth fine with the testimony? I don't want to have a jury sitting here and having to take a recess because this has not been addressed or thought about.
Your Honor, given the fact that Commonwealth is intending to offer some of those text messages in which are the same subject of that, I would not be objecting to the experts, the entering of that evidence through that expert.
Fine. All right, and Commonwealth, your theory with regard to the A and B and it's charged strangulation and suffocation. Is it strangulation and suffocation? Are you going on both on one?
It'd be, Your Honor, strangulation as well as intentional assault and battery.
Perfect, thank you. All right, let me just take a minute.
All right, so trial is starting. We will not miss the what lets us know trial starting. So we're like a minute behind. We'll get caught up. But here we go, guys. Day 1, jury selection.
Court, all rise.
The famous hear ye.
Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Jeanmarie Carroll, First Justice of the District Court, now sitting in Dedham, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This honorable court is now in session. You may be seated.
We can also
In the matter of the Commonwealth versus Stefon Diggs, docket 2554 CR 1862. Are both parties ready for trial?
Good morning, ADA Drew Virtue for the Commonwealth. Commonwealth answers ready.
Andrew Kettlewell for Mr. Diggs. We're ready.
Sir, if you please stand and face the jurors. Sir, you are placed at bar for the trial, charged with one count of strangulation or suffocation, in that it is alleged that on December 2nd, 2025, you did strangle or suffocate, as defined in General Laws, Chapter 265, Section 15D-A, Jamila Adams, in violation of General Laws, Chapter 265, Section 15D-B, and one count of assault and battery, and that it is alleged that on December 2nd, 2025, that you did assault and beat Jamila Adams in violation of General Laws, Chapter 265, Section 13AA. And these good jurors whom I shall call are to pass between the Commonwealth and you upon your trial. If you should object to any of the jurors, you will do so after their names are called and before they are sworn. You have the right to challenge 2 of the jurors without giving any reason for doing so, and as many more of the jurors as you shall have good cause to challenge. You may be seated, sir. Will the jurors please stand and raise your right hands? Do each of you severally and solemnly swear or affirm that you will give true answers to all questions put to you by the court or at its direction, so help you God? Okay. You may be seated. At this time, I'm going to introduce the attorneys on this matter, as well as potential witnesses that you may hear from. Representing the Commonwealth is Assistant District Attorney Drew Virtue.
Virtue.
Good morning. My name is Drew Virtue. I'm an Assistant District Attorney with the Norfolk District Attorney's Office, and it's going to be my job today to present evidence to you supporting the defendant's guilt. Thank you.
Representing the defendant is Attorney Andrew Kettlewell and Attorney Sarah Silva.
Morning, ladies and gentlemen. My name is Andrew Kettlewell. Together with my partner, Sarah Silva, we have a law firm in Boston with the privilege of representing Stefon Diggs.
And potential witnesses that you may hear from. As I call your name, if you just please stand and face the jurors briefly Jamila Adams of Georgia.
That's the
Officer
chef,
Kenneth
right?
Ellis, Dedham Police Department. Anna Kokolis, Sandy Spring, Maryland. Melissa Goddard, Fort Lauderdale, Florida. Michael Perry, Boston, Massachusetts. Janelle Sales of Virginia Beach, Virginia. And potential witnesses who you may hear from who are not present: Juliana Stratati of Foxborough, Massachusetts. Stephanie Anastasi of Methuen, Massachusetts. Natalia Moses of New York, New York. And Zia Charles of New York, New York. And the potential witnesses may be seated. Presiding over this trial is the Honorable Justice Jeanmarie Carroll.
Thank you. Good morning. I am Judge Carroll. Thank you for being here today. As you have heard, we are about to choose a jury for a criminal trial. The defendant, Stefon Diggs, has pleaded not guilty to the charges of strangulation and assault and battery. To assist you in planning, the lawyers estimate that this matter will take 2 to 3 days to try and present all of the evidence. The jury will then meet to discuss and consider the evidence and issues in the case, which we call deliberation, and to reach a decision, which we call a verdict. There is no set time for a jury to decide a case. It will be up to the jury to take all the time it needs. During the trial, while evidence is being presented, our schedule will be to take our lunch and recess between 1 and 2 o'clock and shorter recesses during the day as necessary or convenient. We generally recess for the day by 4:30 p.m. And of course, a trial that does not conclude today would be resumed tomorrow morning and jurors expected to return. The prosecution in this case alleges that on December 2nd, 2025, Stefon Diggs slapped and choked Jamila Adams in her bedroom at 7 Schoolmaster Lane in Dedham, Massachusetts. The defendant denies these allegations and has pleaded not guilty to the charges. To prove the defendant guilty of the offense of strangulation, the Commonwealth must prove 3 things beyond a reasonable doubt. First, that the defendant intentionally applied pressure on the throat or neck of Jamila Adams. Second, that the pressure was substantial. And third, that the pressure interfered with the normal breathing circulation of blood of Jamila Adams. In order to prove the defendant guilty of committing an intentional assault and battery, the Commonwealth must prove 3 things beyond a reasonable doubt. First, that the defendant touched the person of Jamila Adams. Second, that the defendant intended to touch Jamila Adams. And third, that the touching was either likely to cause bodily harm to Jamila Adams or was offensive. Now, jurors, as we begin today, first and foremost, I instruct you that all parties stand as equals before the bar of justice. All parties are entitled to a fair and impartial jury. That is, jurors who will fairly evaluate the evidence, follow the law as instructed, and render a fair and just verdict based solely on the evidence presented at this trial. Jurors, of course, are expected to bring their own life experiences, thoughts, opinions, beliefs, and common sense to this court and the deliberation room. Everyone, including me, makes assumptions and forms opinions arising from our own personal backgrounds and experiences. These biases or assumptions may have to do with any number of things, including an individual's race, color, nationality, ethnicity, age, disability, socioeconomic status, religious beliefs, gender, or sexual orientation. I instruct you that a verdict must not be based on any such bias, including conscious or subconscious bias. Whether conscious or subconscious bias can affect how we evaluate information and make decisions. It can impact what we see and hear, how we remember what we see and hear, how we make important decisions, and may even cause us to make generalizations or to prejudge. While each of you brings your unique life experience with you to court today,
As jurors, you must be alert to recognize whether any potential bias might impact your ability to fairly and impartially evaluate the evidence in this case, follow my instructions, and render a fair and just verdict that is based solely on the evidence presented in this case. I will now ask you to respond to some questions that will assist us in obtaining a fair and impartial jury. If your answer to my question is yes, please hold up your juror card and the court officer will read your juror number out loud. At the end of my questions, you will be called up to the judge's bench one at a time so that the attorneys and I might speak further with you. Now, there are 4 fundamental principles that you must follow in this case. The first principle is that the defendant is presumed to be innocent. The second principle is that the Commonwealth must prove the defendant's guilt beyond a reasonable doubt. If it does not, the jury must find the defendant not guilty. The third principle is that a defendant has no burden to present any evidence and has an absolute right not to testify. If a defendant does not testify, you may not use it against him in deciding the case. The fourth principle is that the jury must follow the law as the judge explains it. Is there anyone here who does not understand or agree to follow these 4 fundamental principles? No affirmative response. Do any of you know or are you related to the defendant? No affirmative responses. Do you know or are you related to any of the attorneys or any of the witnesses whose names have been announced? No affirmative answers. Have you read or heard anything about this case?
Just hold them straight up, jurors. Thank you. Juror number 46. And when I call your number, please put your card down, okay? Juror number 32. Juror number 25. Juror number 41. Juror number 42. Juror number 55. Juror number 6. Juror number 4. Juror number 43. Juror number 16. Juror
Also,
number
guys,
18.
Chicken Shite said that
Juror
I
number
bet the chef
24.
put raisins in the potato salad.
Juror number 13.
It's fighting words.
Juror number 27. Juror number 7. Juror number 22. Juror number 17. Juror number 21. Juror number 58. Juror number 34. Juror number 51.
Number 29, number 49, number 47,
And remember, they need to impanel a 6-person jury,
number 54,
maybe an alternate or 2.
55, number 36, number 14, and number 8.
Do you have an interest that would be affected by the outcome of this case? No affirmative responses. Have you expressed or formed any opinions about this case?
Juror number 27.
Are you aware of any bias or prejudice you have towards either the defendant or the prosecution?
Number 37,
Do you know of any reason why you would not be fair and impartial in this case or able to render a true and just verdict based solely on the evidence and the law?
Juror number 13.
Is there any reason, for example, personal concerns, difficulty with English, physical or medical concerns, or religious or ethical beliefs that would make it difficult for you to be a juror?
Juror number 42. Juror number 41. Juror number 26. Juror number 50.
Nick Starro just
number
sat a
23.
5-panel jury in the chat, gifting 5 memberships.
37.
Guys, wish Nick happy birthday. Nick, happy belated birthday. I've been trying to tag you. I was busy this weekend, but I got to come tag your chat.
Would you believe the testimony of a law enforcement officer, either more or less than the testimony of another witness, simply because the person is a law enforcement officer?
Juror number 19. Juror number 50. Juror number 23. Juror number 43.
Are you a close member of your family or a close friend employed in an area related to law enforcement or criminal defense?
Juror number 32. Juror number 43. Juror number 23.
Juror number 22. Juror number 24. Juror number 38. Juror number 34.
Number 9. Number 49. Number 54. Number 35. Number 36. Number 14.
Shout out to Moses dropping another
Do
10
you believe that if a person is arrested or charged with a crime, they must be guilty?
This is a big question. I don't know how many people are truthful in answering
No
this one.
affirmative responses. Have you, a close family member or a close friend, been involved in a situation with domestic abuse or violence or with a related court matter, such as a Chapter 209A abuse prevention order?
Juror number 50. Juror number 41.
Juror number 24.
Number 37. Number 29. Number 54. Number 28. Number 35. Number 8.
Have you or anyone close to you ever been the victim of a physical assault or abuse?
Juror number 23. Juror number 50. Juror number 43.
Number 37. Number 45. Number 28. Number 35. Number 36. Number 8.
And juror number 1.
Have you or has anyone close to you ever testified under oath in a court proceeding or other formal setting?
Juror number 42. Juror number 41. Juror number 25. Juror number 19.
Juror number 27. Juror number 7. Juror number 22. Juror number 48. Juror number 18.
Number 54. Number 35.
Have you or anyone in your household ever felt that a legitimate complaint, grievance, or medical concern was not taken seriously or was dismissed by an employer?
Good
Juror
question.
number 50. Juror number 43. Juror number 42.
Juror number 27.
Have you, a close family member or close friend, been charged with a crime like those in this case, or been a witness in or affected by a matter where an individual was similarly charged? No,
Number 35.
thank you. Is there anything about the charges in this case that would make it difficult for you to be fair and impartial?
Juror number 50.
Juror number 27. Juror number 13.
Number 8.
Do you know of any reason why you would not be fair and impartial in this case or able to render a true and just verdict based solely on the evidence and the law?
Juror number 13.
All right. Counsel, I'll see you at sidebar.
All right, so they're going to go up there. When they go up there, they check in and say, all right, we want to strike whatever numbers. Oh, is there going to be a booping every time there's a sidebar? Okay, they silenced it, so that's good. Factual lie says juror 50 really wants out. And guys, a couple questions about the Folio 4 trial that we've been watching. That's set to start late today anyway, and because this trial seems like it's going to be a mess, like the complaining witness, the alleged victim, seems like the attorneys believe she's going to plead the fifth. So I think we're going to watch this one straight through, and we'll catch up with Folio 4 this evening after court ends here. So that's going to be an interesting day, though, because Robert Howard's going to take the stand. And if you watch the Alicia Andrews trial, I think he was I thought he was the most interesting witness. Okay, we have some space to jump. So, not much, but... Oh, you know what? I wonder... Maybe when they're dismissing jurors, they're saying names and whatever, so maybe they're just... While they're dismissing jurors, they're told to shut the camera off. So, we will see. Miss Jones says, I don't think I've ever watched jury selection. It's usually not part of trials that are streamed. Like, jury selection doesn't always get the broadcast, even if the trial itself is streamed. But recently, we watched jury selection in the Afro Man trial. And I thought that was just so interesting to watch. If you didn't follow the Afro Man trial, it was a free speech case. It was a civil case. And the idea that Afro Man was making songs after police raided his home and cash was missing or miscounted, however you want to characterize it. And he made some songs talking about the situation. Why did you cut my cameras? Why did you raid my house? And so the officers, 7 of them, got together and filed a lawsuit against Afro Man. So pretty interesting jury selection there, because you want to seat a jury panel that, if you're the plaintiffs, would be sympathetic to a major artist making fun of you for doing, quote unquote, your job. That's the plaintiffs who you want to seat. The defense, Afro-Man, you want to seat people who, hey, even if it's crass, even if it's not something you would say, still have a First Amendment right to criticize the police when they do certain things. And so either the facts of the case and or the jury selection, that all went in Afro-Man's favor. The jury returned on all counts in favor of Afro-Man and nothing for the plaintiffs. But it was cool to watch the jury selection there. And overall, I agree. Trial was awesome. The trial was awesome. KLF says that's a, maybe it's an Ohio thing, because Afro-Man was in Adams County, if you don't know from his song lyrics. But KLF says Warren County, Ohio shows jury selections all the time. So that's actually cool to know. Maybe we can just tune in. Do a roulette like Dolly Talk does, but instead of the trials, just jury selection. Also, while we have some downtime, I want to show some love. Chicken Shite has been a member for 9 months, always bringing humor to the chat. One of my favorite profiles to see pop up in here. Not just because of the commentary, but the commentary with the picture is just like 10 out of 10. Paulette C with the kind words saying, I'm from Massachusetts and I'm so happy you're covering this. Love you all. Well, we're glad you're here, Paulette. Tell us about this brother-sister thing you guys have going on over there when addressing counsel. Hope you're doing well. Thank you so much for the super. Moses Dupree dropping... Well, wait, hold on here. I'm doing it backwards. First got his cigarette and his Mountain Dew ready for this trial. I think it's going to be a messy one, a chaotic one, an interesting one. Also bringing along 10 gifted memberships. So we're seating a jury in the chat. We've got 25 jurors seated so far. We had Nick Starrow come in and gift 5 very generously. And if you heard me mention earlier, he recently celebrated his birthday. In Sweden, birthdays are tied to, more personally identifying information than usual. So we're just going to not give a date, but we're going to say all week long, we are celebrating Nick Starrow's birthday. So happy birthday to Big Nick Starrow, one of the best places to watch courts and trials here on YouTube. So I'll drop a link for you guys in the chat if you don't already follow him. Then Moses gave 10, right? So that puts us up to 15. We are impaneling the best jury here in the chat. Brooklyn came in with another 5, so shout out to Brooklyn. Let's get some love for Brooklyn in the building. And Sheriff Chuck for another 5, who he is so generous with the gifts. He has his own Party Chuck emoji. So just drop some of those in the chat. And if you guys turned green, there are some channel emojis for you guys to use. Who knows? Maybe we'll add a new emoji specific to this trial. If there should be one or one that you think of, let me know. I can see about creating one and swapping it in. And show some love. That was very generous starting off here. We have all of these gifts from very generous people. So thank you guys so much. And let's see. I've got everyone in the banner. And I'm also going to check. All right, let's refresh the AP and see if they moved inside. No, they ended their stream. So the AP feed, they're just showing the outside of the courtroom, I guess, when everyone enters and leaves for the day. This here is NBC 10. Seems like they're the one running the media pool. And I feel like they would have kind of quickly stricken the jurors, so I don't know why we're still on the live view screen. But maybe they're doing... Maybe they had to bring the jurors up to the bench, and so there's no way to, like, show them not on screen. So I don't know. If you guys want, we could continue watching the rest of the pretrial hearing. It seems like we kind of got through the substantive issues, although they take a break for like 10 minutes during that hearing. And it looks like they come back for like, let's see, 46. For like another 15 minutes. Also, Asia Mullen, an OG on this channel. Thank you for being a member for 17 months. Holy moly. Hope you are doing well. And I'm a little late here, but just dropped Nick's link in the chat. Okay, let me get this banner. All right, so while we wait for court action, we are toggling back over to this pretrial hearing. We just went over, they went through a couple of last minute motions, witness disclosure at the last minute saying that she'd witnessed a prior altercation involving Stefon Diggs, and it sounded like the alleged victim and someone else, a third person, was there. Then we heard from the defense that they believe that the alleged victim, Jamila Adams, is going to plead the fifth on the stand at some point, and the Commonwealth seems to be aware of that. They are going to exclude the word victim. There's no objection, so they're not going to refer to Miss Adams as a victim during this trial. It's something that the jury gets to decide. And let's see. The defense wanted preliminary instructions, so the instructions that are read before everything starts. Wanted the instruction on witness credibility, which is hilarious. It was denied. That request was denied. And then what else? I guess there's going to be maybe issues about authentication of a phone. And Stefon Diggs plans to call a witness who handles like his management, seems like payroll, administrative type stuff, who would have been doing correspondence back and forth relating to the chef's pay. So that's what we missed so far. And we stopped here.
Before you all leave, and let me read that motion over, and I will come back to it. So, Madam Clerk, just a brief recess.
All right, so they take a recess. We can skip that in this preliminary hearing.
Court, all rise. So, on court is back in session. You may be seated.
Back on the record, Commonwealth versus Stefon.
All right, so looking over that motion, it certainly is very vague and details are absent, so there's nothing really about this alleged prior event. I think as the Commonwealth suggested initially, Commonwealth, you're saying you didn't have any particulars about time, place, manner, means, nothing of that kind, echoed obviously therefore in the defendant's submission. So that information is any reference to any prior bad act is excluded unless there's some further detail or some other argument that we have to take up. But she's also to be instructed that that should not suddenly slip out. So the defendant's motion is allowed. That leaves, I think, the requests that were filed with regard to voir dire. And I just wanted to go through both how I proceed in that regard and what your thoughts were about the particular questions you had submitted on behalf of the defendant. Generally speaking, my intention is to follow the standard questions from the trial court, which do, I believe, also incorporate a few of the issues that you have identified. But I was very curious about your submission number 2. You were asking the court or for counsel to be allowed to inquire with regard to jurors' potential involvement in the healthcare, psychology, therapy, or counseling field. What is the relevance of that particular question? Why that?
So I think this is a case with essentially no physical evidence, no medical records, and I think what we're going to be asking jurors to do, like in any case, is rely on their common sense, their life experience, and I think what we're trying to get at there is just any jurors who might be coming into the process with some degree of expertise that has the potential to take over the jury room, essentially.
Would and you're saying that wouldn't be revealed in the juror questionnaire?
So
asked about their background and.
So I think yes and no. obviously, certainly some of this information would definitely be revealed in the juror questionnaire, just based on people's employment and profession. I think.
All right, so that's probably what they're getting into right now, right? They're probably asking the jurors more individualized questions.
Our question is just trying to get
And that's why we're
essentially
iced
one level
out.
deeper, which is there certain training, work experience that a juror has had that they're not currently involved with?
Well, are you suggesting, is it more that you're looking for, is there any specialized training with regard to these areas? Or, it's such a broad question is what I'm thrown by, quite honestly. And so I think as you present it, I wouldn't be inclined to allow that. But if you end up thinking about something that's a little more refined and you want to suggest it, we can certainly discuss it. But I just think that's so broad.
Understood. Thank you, Your Honor.
The question that you're proposing about employment, that certainly I think is covered in the standard questions. The question that you propose with regard to, have you ever felt you've been treated unfairly by an employer? I wonder if you could just give me a little bit of your thoughts with regard to that as well.
So I think the situation, as the complainant lays out to the police, is she was an employee. She worked for Mr. Diggs as a chef, and I think throughout a 2-week period in December, had a number of complaints about payment, and I think just the nature of that relationship is kind of what we're trying to get at there.
Okay. All right. Commonwealth, do you have any thoughts about that particular line of inquiry?
Your Honor, I think my concern with that is it's somewhat of a one-sided question because it's asking about one part of the relationship and not the other of an employee-employer relationship or dispute.
Do you have any thoughts about how you might suggest that be?
Your Honor, I think it would be, have you had an experience as an employee or employer that makes it difficult for you to be fair and impartial in this case?
I think in part, I was thinking that perhaps, and I don't know, 4 and 5 almost would be merged into something more along the lines of, have you or has anyone in your household ever felt that a legitimate complaint, grievance, or medical concern was not taken seriously or was dismissed by an employer?
We heard that question
Would that
asked.
satisfy kind of where you were headed?
Yes, Your Honor.
It's cool to hear them come up with like how to word this.
Also, the defense has.
And the reason they do this is because you want to be able to seat a jury that can take in the facts of the case, you know, without coming in with preconceived notions or biases that would, you know, be unfounded. They can change their mind as they hear the facts and they can apply their life experiences, but you don't want them coming in with like, I can't stand anybody that's a manager or an employer or is the person who pays someone else's payroll because I had this horrible experience myself. Not the type of person that would be an impartial juror in a matter like this. And reverse, like you don't want a manager who thinks that all claims that come through against the company or someone that works at the company are frivolous and bogus and nothing can ever be true, right? You don't want either of those extremes. It's not, they'd be partial and not impartial. So it's cool to hear them come up with how to word these questions in a way that isn't really making arguments about what position we want you to take if you are seated on this jury and watch the trial. But we got to ask you because we need to know. And I think we color outside the lines a little bit sometimes with jury questions, and a little argument might seep in.
Raised a request for a question along the lines, have you or anyone close to you ever thought about making a report or a claim of a crime or misconduct, but did not end up doing so, basically was the question as phrased. Again, I thought it somewhat broad, but I wonder if you could just elaborate a little bit as to what it is that you're trying to seek or elicit from jurors through this kind of a question.
Yes, so I think what we're trying to get at there is the way that the standard questions frame it and the way that the actual questionnaire framed it is, have you ever been the victim of a crime or been involved with law enforcement? In my own experience, just kind of selecting or talking to jurors, I found that that works almost as a demarcation line to a certain extent, the way people view an event. There are different types of kind of assault or abuse that rise to a level of a report and do not. And what we're trying to do is kind of, I think, get to a question for the jurors that goes slightly beyond the kind of definition that's laid in the juror questionnaire.
Commonwealth, do you have any thoughts about number 6 as presented in the defendant's motion?
Your Honor, I'd suggest that I think that is largely covered by what is the standard question. Being a victim of a witness, victim, or a defendant charged in any crime.
Well, this feels a little bit about not have you just been that, but have you thought about making a police report, basically, or a claim, and then changed your mind? And I just feel that's so, again, I think it's a very broad question. I'm happy to think about it, but certainly it wouldn't be coming out quite that way. I'm perfectly fine with number 7, unless the Commonwealth has some specific objection.
Your Honor, I know there is usually I think it's like a 10-year look back if you or anyone you know or is close to has been a victim or accused of strangulation, suffocation, or assault and battery, which somewhat gets to it. But
I will use that kind of general question as to, it may go to even crimes similar to the ones at trial here. I think it's how the question goes. But sometimes I do think it can be helpful to be a little bit more specific, and I take it that's what you're looking for given the allegations.
Yes, Your Honor.
I thought also number 8, have you or anyone close to you ever testified under oath? Reason for that? What you're trying to, you know what I'm not just your reason and you're thinking,
No,
what
totally
you're trying to
understood.
extract.
Basically, experience with the court process, experience with actually testifying. One of the reasons I've asked that is, I think for many jurors, if they're involved as a juror or as a witness in a criminal case, that certainly comes right to mind, but restraining orders, depositions in civil matters or divorce type cases tend not to, in my own experience. And so that's just part of what we're trying to ask, is whether specifically that's something they've experienced.
And isn't the issue, though, that would impact your ability to be fair and impartial in this case and to decide this case based on the evidence in the law? Isn't that the thing we're trying to connect all of this to?
Yes, Judge.
So I don't think that question that's raised kind of closes that loop. But Commonwealth, though, do you have a thought about going down that road?
Your Honor, I think at least I know my brother's saying he's experienced differently. At least my experience with jury questionnaires, jurors will put restraining orders, civil litigation, divorces, things like that on questionnaires.
They do. In fairness to the defense, I do think sometimes, and that gives us a chance to follow up at sidebar and inquire a little bit more. But I understand why you're trying to just push it a little bit further, and I will certainly think about that and where perhaps to put something along those lines in for you. And there, of course, there will be questions throughout with regard to media and things of that kind. Is that the purpose of number 9, of the public nature of certain kinds of trials, as opposed sometimes to other? Every trial's public, but some of them seem to invite a great more public interest than
Yes, Judge.
our everyday events. Okay, so that will come up a few times, I think, in the inquiry the court will make. One question I have for you, obviously, ABA Virtue and I have paneled cases together. My practice always is to put all of the questions to the venari, and then to have every juror, no matter what, come up to sidebar for further questioning because of whatever they may have raised their card to, but also because there may be just some issues that also off of their questionnaire are important to further explore. Is your request to be able to directly inquire as to a couple of these issues?
Yes, that was our request for.
So my answer to that is I'll give you each 2 questions, and I need to see those questions beforehand. So if there's some of these that we've been discussing that you want to use, that's fine. And if you want to put those yourself to the jurors, that's fine. So each of you have 2 questions, not each lawyer, each side. I saw it. So, all right, does that seem doable? Okay. So, any other issues that you were?
We do have a proposed statement.
Oh, thank you.
It can be retyped if you want that as well.
We can type that
Thank you.
for
Thank you.
Monday.
Your penmanship is outstanding.
I did have a couple housekeeping matters, Judge.
Sure.
So I guess the first was just with regard to the witness list. The witness number 11 on there was his mother, the defendant's mother.
Yes.
I don't anticipate that she's actually going to be a witness in the case. Speaking of my brother, I don't think he's going to call Mrs. Diggs either. I essentially put her on the witness list because she was in and around the house through various times, and I expect her name to come up.
Yes.
But I would ask that she not be subject to a sequestration order so that she can actually sit in and watch the trial.
So do you want to strike her from your list?
And I think that's probably the best way to do
All
it.
right. So she'll be stricken from the list. I'm certainly welcome to stay.
The mom can be in the gallery.
And then the other issue I wanted to raise for the court with regard to our witnesses, the defense witnesses, was we have two witnesses who I do not think are going to be available to be presented to the jury on Monday. Two that I'm absolutely aware of. Now, one is out of state and coming into Boston, who I expect will need to call her as a witness on Tuesday. And the other witness is in school on Monday. And so...
Is she out of state in school?
No, she's in school in Massachusetts, but I think in classes on Monday morning. So I can talk to her.
Talk to her, maybe she should just be on call. And obviously, it's going to take a bit to pick a jury in this case and then to get started. And I don't know how far we'll get on Monday. And I certainly imagine this will go into Tuesday, and you might have some adjustments to the order of things, and probably can work that all out. We should be able to
Yes, Judge.
figure all of it. My hope would be to be moving, though, forward once we start to not have these. Obviously, there is an adjustment if somebody's, a few minutes away or something of that kind. But to hopefully press forward.
That is our hope as well. And to that end, I wanted to, I guess, check with the court if there's a logistical kind of manner that we could help our kind of procedure along with. If there's a place where we could have witnesses who we actually get in the building, in the courthouse, seated, where they might not have to kind of be subject to questions in the hallway or anything like that. If there's
Well,
a
let's see what how about we revisit that on Monday. Obviously, for starters, we need to get a jury. We need to address issues involving the complainant in this case and get started. Once we've done that and we start to be headed towards shifting to the defense case, then I think it makes sense to look at that and to see also what does money look like in terms of the courthouse and availability of spaces.
Sure.
But see what we can do.
Okay.
Okay. It's a very reasonable request, counsel. Anything else?
No, Your Honor, I know that we had spoken to, I think, I don't know if it was this clerk or a previous clerk, about perhaps pre-marking submissions and or creating essentially like a binder of submissions. I know that's not complete or in material form yet, but I know that's something that my brother and I have been working on.
If you have an agreement on that and it makes things flow more smoothly and in a clearer fashion for the jurors, I think it makes a lot of sense. All right, is that it for today?
That is it.
All right, thank you. Have a nice weekend.
Thank you, Your Honor. You
Keep
as well.
listening for trial, nothing before 10:90.
All right, so again, that's Judge Jeanmarie Carroll. That was a hearing from Friday, and the next most recent thing is what we're watching today. Also, Law and Crime has fired up a feed. They have closed caption, so they're still not, court's not back, at least not being broadcast. So, I mean, and I don't know exactly what's going on. My best guess is they're going through the jurors. They might be saying, like, where do you work? And they're not going to broadcast questions like that, even though they'll broadcast the generic selection questions for us. So, let me take down this banner. Let's see. Quirky's saying it's sounding like a Cardi appearance. Is it? Is it? I don't know. Let's see. Leave the courtroom alone. Miss Gibson's like, it looks yellowish and old. Yeah, we've been watching the Julio Fulio 4 trial, and that's down in like the Tampa area, Hillsborough County in Florida. And the witness stand just has this, like, stage theater. It'll be dark, and then they have those overhead, the theater, the stage lighting. The witness stand, the lighting in that trial just gives that vibe to me. And so anytime anyone's testifying and the broadcast is showing it, it's just such an odd thing to open up a court stream, and that's the cinematography of it all. So that's been an interesting one to watch. Here everything is just sort of like these muted but warm, woody colors. EJF does not like the Melly courtroom. They've got that. Is it like a marble slab behind where the judge sits for Melly? And it's an odd angle the way that that's being streamed from. I guess it's the best place for them to put the cameras for Melly. Let's see. Yeah, Mavka, I'm wondering that too. I don't think they'll return until openings. That might be the case. That might be the case. What we could do, if I end this stream and do a part 2 whenever they come back, as soon as I end the stream, that could be when they come back. If I don't end the stream, they'll take a very long time. So, that's always how it seems to go. Let's see. Yeah, lawyer by heart, not the bar. Yeah, there was discussion. They continued discussion about some of any reference to prior bad acts being like, don't even try to slip it in, don't try to mention it. It seems like that's related to the first motion at the beginning of that hearing relating to a late disclosure of a witness who said that she'd seen a prior altercation and that somebody else was also there. So Moses says, bought some blue Chanel this weekend. I'm ballin'. Love it. Well, thank you for the 2 here. And thank you for the recommendation for anyone, shopping around. You gotta rate it. Like, I don't know if you've worn it yet, but you've got to tell us, like, when it first is applied, and then after you've been wearing it for a good portion of the day, does it change? Do you still like it? Yeah. Shannon says Cardi's too busy. Busy and booked. I mean, she just got done with like a massive, massive tour finale. Like, everybody was at her final 2 shows. Drew Findling was there. Attorney Drew Findling for, several people, but Dirk, Melly, he was there. Her tour page posted his picture. Well, I thought it was great. I've never watched Drew Findling make arguments before. I've just, I've heard he's a great attorney. I thought his arguments in Y&W Melly's bond hearing, the Arthur hearing, I thought they were great. They were reminiscent of, if you guys remember, when Jeffrey Williams, Young Thug, took his plea, but Brian Steele gave some arguments before, because it was a non-negotiated sentence, right? So Jeffrey Williams is really putting his fate in Judge Whitaker's hands. And Brian Steele for the defense, gets to argue, had this gone to trial, here's what we would have presented, here's what we would have argued. And Brian Steele was just like, it was like he was finally getting something off of his chest, all of the things he'd been waiting to say, that he never got to argue to a jury, because Jeffrey Williams took the plea deal. And it reminded me a bit of that. Like, Drew Findling got on this case a few months ago already, but it's the first time he's really gotten to make like a full-on argument. So I thought it was cool to watch. All right. The blue Chanel rating. It's awesome. It's strong too. You just need like 2-3 sprays. Brave's like, I can't believe the Clenny case hasn't started yet. I mean, there's going to be like I feel like so many cases that we've gotten together for on this trial that have started and finished before Courtney Clenny finally has a trial date set. It's still there. There was a quick status hearing. It was like 2 minutes long, where everybody needed more time. They're going to meet again on June 1st for another check-in, another status hearing. And the judge said something to the effect of, I think we can make August work, because the defense said that they still want to be on track for trial in August. So still no actual date set. And they've been trying for August since the last hearing before that. Yes, I don't know. Courtney Clenny, the trial that never starts. And there's been like, I feel like 5 or 6 documentary things about the Clenny case already. It's like the reverse order. Yeah, this is kind of where I think lawyer by heart, not the bar, says he was phenomenal, talking about Drew Findling in the Y&W Melly case for the Arthur/bond hearing. He was phenomenal. I don't think the judge will release him. However, I do think that he will order some changes with confinement. And I think that's fair. I think that would be fair. Apparently the attorneys had difficulty, they want to go meet with their client. When you're in custody, you don't just have free time and a bunch of resources. You're not at your home pulling up your own computers to say, I'm going to look at my case and start working on my defense. You don't really have that freedom to do so while you're in custody. And your attorneys, sure, you get visits with your attorneys, but if the restrictions are so tight on when they can get there, it's not always practical for them to just come meet with you all the time. So that can really hinder preparation for a defense. And I think Drew and Carrie, his attorneys, are going to be ready to go. I think they're eagerly anticipating this trial date, which is now set for January of 2027, and they want it to stick. But still, I mean, it's the more difficult it is for the attorneys to meet with their client, it hinders some of the conversations that you would want to have in preparation for the trial. And I'd heard that the attorneys wanted to meet with him a few days ago, but because of the scheduling and all of the red tape that they have to go through, the meeting didn't work out. So it'd be cool if some of the changes in confinement would relax and enable that. I think that's only fair. And Dizzy says, is there really a chance, though, considering he's facing death penalty? I mean, it's all likelihoods, but in Florida and several other states, there is a pathway for it. So you're not entitled to a bond when you're facing a capital charge. But through what we call an Arthur hearing down here in Florida, you can request an opportunity to be heard to get some form of bond so you can have pretrial release. And to me, it's always like a mini trial. Courtney Clenny has done several, and they've likewise been denied. But you can watch her first Arthur hearing / bond hearing. It was like a 2-day presentation. It was a lot of information. That's why I say it's like a mini trial, where the state needs to show that, look, we've got all of this evidence. It's like her that did this. And it's a little bit different for Courtney Clenny because she's taking an affirmative defense, right? She's not denying that she's the one that inflicted this wound, but she's challenging whether or not that wound was necessarily fatal, the intent behind it, whether there was justification. So her presentation for the Arthur hearing was a bit different. For Melly, he's denying, involvement with any intent to commit what he's charged with, right? Not an affirmative defense. It's a denial. So a little bit different. Where really, I think Drew Findling's tackling was, there's no definitive evidence, and the affidavits were signed by an unreliable Detective Moretti. He's a liar. The appeals court thinks he's a liar. So, that kind of, Drew Findling argued, should take the weight that the state's claiming they have against my client down a notch. And that wouldn't reach the proof evident presumption great standard that's required for the state to prove they have the burden for the purpose of an Arthur hearing. But at the same time, practically, I don't really know that a judge would love the idea of coming in and saying, look, this has been denied several times before. I'm going to toss it up and change it. And I would think if Judge Fine makes a decision that's favorable for YNW Melly, it's because of the state's behavior. I think it would be because of the state's behavior. This decision to bring a whole witness tampering trial case, and then the day trial is about to start, they just null pros everything. They drop all the charges. And then they issue a statement the next day. They file something the next day blaming the court, saying it's the court's fault that we had to drop these charges. I don't know if it would rock the boat enough for a judge to want to counter rock the boat. But I'm just saying, I think if we do have a decision like that, it would be the state's own doing rather than an evaluation of the facts of the case. So, yeah, and that's also, Brooklyn, that's true too. Courtney also didn't have a mistrial. Melly had a mistrial. Although, again, there's been a decision on a denial of bond since the mistrial. So that's not the new circumstance that gives rise to this change in circumstance that should warrant a reconsideration. The arguments were a little bit different. I do think a big shift is the change in representation for YNW Melly. These attorneys aren't caught up in search warrants and potential other conflicts of interest. So, what I didn't really think was great As soon as we got done arguing for bond, right, they move on to another issue, and Melly's team says, look, we're still having issues with prior counsel, like Liberty Raven, her team, turning over all of the stuff that they were given in discovery. You know, when counsel takes over, you're supposed to pass everything forward to new counsel. And they're saying, we're not sure that everything's been sent over to us, that we've gotten everything that we're supposed to have. Can we meet with the state to check on this? Now, it's not a problem for them in a bubble to just say, like, hey, we want to check on that. But what is kind of interesting is Drew Findling just got done arguing, we've seen everything in this case, and there just isn't evidence to meet the burden, the state's burden, of the proof evident presumption great standard, which is stronger than beyond a reasonable doubt. And I didn't think it was great to, like, you just got done saying that, and then you come and say, we're not sure if we've seen everything. So, but you know. Let's see. Oh, and you know what? Let me see. Let me see if the outlets have put anything in the chat. Nothing from NBC 10. Because sometimes they'll mention, like, hey, we're not broadcasting right now because XYZ. Let's see if Law and Crime has anything in their chat. Okay, so Law and Crime only says jury selection's underway and the pool turned off the camera for now. That's all they provided as context. So yeah, I'm going to assume that this is because they're getting into personalized or questions that could be personalized, where the nature of the questions could reveal identifying information, or, you know, someone that's really sleuthy out there could be like, oh, they mentioned that they're employed by this place, or there's only one place in this area that does that. Let me go find out. Like, you don't want that stuff being broadcast. So, because people are crazy. Nancy, new one too, is wishing another Fulton County case upon us. All right. Who in the chat here has experienced, well, we'll just leave it at Massachusetts, generally speaking, and a Fulton County case through a trial watch? Because if you've survived Karen Reed and YSL, I think you're equipped for any trial. It's a lot. To watch both of those trials is a lot. T. Wood says, is Melly co-defendant going to testify against him? I don't imagine so. I don't think that, you know, from the rumblings, I don't think that anyone's even trying to have him come testify. I mean, it's just such a... think about it. If you were the defendant, if you were about to be on trial, and the state wanted to call Bortland, who pled down, and somehow, like 10 years is his sentence. Meanwhile, you're facing the death penalty. I don't see a reason the defense would want to call him. Yeah, a lot of survivors of both trials here. Definitely wild times. This case, anyone tuning in now, there is a longer description in the description, this case background in the description, but this is the criminal case that Stefon Diggs is going to trial for. So this is the Commonwealth of Massachusetts prosecuting him. He's facing a felony strangulation charge and a misdemeanor assault charge. And it all relates back to an incident where his personal chef, who, you know, lived in his Dedham, Massachusetts home, there was issues and arguments over payment. It seems like they were messaging each other about it first, but it became face-to-face and got physical, according to her. Her name is Jamila Adams or Jamila Adams. The name's kind of being pronounced both ways. And she's saying that, look, this confrontation, it got physical. He smacked me across the face. I tried to push him away from me, and then he strangled me with the crook of his elbow, like that type of motion. And 2 weeks later, she reports it to the police. She doesn't report it right away. Now, pretrial, right? Outside the presence of the jury, we just watched the pretrial hearing from Friday. It seems like everybody's under the impression that when Adams testifies, and she's the star witness, right? This is a he said, she said. She's the one that has to attest to the elements of these crimes. Because if not her, who else? You know, she said she didn't take any photographs, so it's not like the state could rely on something like that in lieu of her testimony or in support of her testimony. And seems like she might plead the fifth. So, and I don't know exactly what that means, right? Everybody, you can invoke your rights, right? Unless, prosecutors will try to get immunity waivers sometimes, where they say you no longer need that privilege. And some people just insist on pleading the fifth anyway, like Woody in the YSL trial. But I mean, you could say it just to prevent something that could be used against you. It doesn't necessarily mean that you're hiding something bad. But I think that people in general, when someone pleads the fifth, it seems like they're hiding a bad thing that they did. It's just like the gut instinct way that it comes off. So, and I heard that this morning, this is going to be a chaotic trial. I love that the prosecutor's name for the Commonwealth, his last name is Virtue. Let's see if he lives up to his name, Mr. Drew Virtue. So, yeah, and I don't know. Quick, share your comments in the chat. If the complaining witness, the alleged victim in this case, nobody can call her the victim for the purposes of the trial. That's the jury's job to determine. So state can't just come out, the Commonwealth can't just come out and be like, and you're going to hear from the victim. They've got to say, you're going to hear from Miss Adams. But let me know in the chat your thoughts on if you're watching this and the key witness, the star witness, pleads the fifth on the stand. Would that sway you significantly towards not guilty? Yeah. Nick says, I would pay to see the Bortland cross, especially if he can't plead the fifth. Poke Fairy says, if she pleads the fifth, there's no case, surely? Question mark. I mean, I think it would not be great for the Commonwealth. Of course, maybe they'll try to avoid questions. Like, do you think the Commonwealth will try to avoid the elephant in the room? Do you think they'll try to get ahead of it? Because I would imagine whatever it is, the defense is going to want to impeach this witness. I mean, it would be it'd be stupid for them. It'd be a bad representation of their client not to. I don't know. Yep. That's a good point too, Dizzy, with the reminder here that, there isn't an instruction. If the defendant has to invoke, there could be a instruction given to the jury. But for a witness, the jury can hold that against her, can hold that against a witness when assessing their credibility. So it's a big deal. And again, to me, this comes down to, I'm always interested in the initial story, how things are reported, people's initial reactions. To be accused of anything that involves some form of like abuse, and I would say this kind of falls under the umbrella of a domestic dispute, not because they're in any sort of relationship, but because she was residing in the same house, right? That's like a closed quarters type of environment. So when you hear, oh, somebody strangled someone in her bedroom, it's such an inflammatory thing to hear. And then months go by, and I do think this is happening pretty quickly, that we're getting to trial when this incident happened in December of 2025. But not as many people are tuning in to the trial and what's happening. Not so many people got to hear, well, we have this last minute witness, but the judge found, look, unless there's any other supporting evidence, proof, any reference to prior bad acts is going to be excluded. Don't even try to mention it. Those aren't things that are making the headlines and being sent around as loudly and widely. And I really don't think you can ever truly undo the damage. Let's see. Dizzy's predicting that since this is Norfolk, they will avoid. Yeah, and a lot of people are saying probably would sway me, or yes, or it depends on what else. And I think Mavka's got it right here that it depends on what. It depends on what she would invoke if she does in fact invoke her fifth, what the question would be. Like if the question's kind of generic, like have you ever, and it's not like in relation to Stefon Diggs, have you ever done a bad thing? Right? Maybe it wouldn't be so bad. But hey, Kelly, good to see you. Kelly checking in from Texas. Hey, Afton. Ooh, and Mrs. K Grift with the good reminder, guys. If you switch to all messages in your YouTube window, you'll see everybody. I don't know how the top messages function works on YouTube, but it cuts random people out of the conversation. So if you switch to all chat, you'll see everybody. You won't miss any of the conversation. And I always forget to do that, so always appreciate the reminder. Mavka says I'd convict any Patriot, Celtics, or Red Sox player. Dang. Baby Tsunami, they're still in jury selection, but I think the questions got more personal, so they cut off the broadcast. I mean, this is the broadcast feed. They just had to cut their camera, their live camera. So yeah. And RM Mama says, how could she make a case while taking the fifth? So here's the Commonwealth, the government's job to make the case, since this is a criminal case. They could, in general, the government, when it comes to criminal prosecutions, they can choose to prosecute even if a witness doesn't want to cooperate, even if the alleged victim doesn't want to cooperate. Do they typically choose to do so if there aren't other things like photographs, if it wasn't reported right away? Typically not. And that's not necessarily because the prosecution's making a determination. If they choose not to bring something to trial, that isn't strictly because they think, we don't think that this is true. We don't think the story actually happened. It's just, we have a burden, we have a ethical duty to not bring cases that we don't think we even come close to meeting our burden for. So sometimes when something actually happens, but the star witness, possibly the only witness of something, doesn't want to cooperate, and then there isn't anything else, like physical evidence, forensics, that could help the state, they just don't have something that they can ethically bring to trial. But here it seems like the witness kind of wants to cooperate, but kind of not. And remember, invoking, you can plead the fifth, but you still can't perjure yourself on the stand. Yeah, I think this is another way to complement what Dizzy pointed out earlier, another way to contextualize the difference, right? So, and again, the context that we're dealing with invoking here is for a witness, not for someone, it's not for the defendant in this case. The defendant in this case is, of course, Stefon Diggs. But if someone pleads the fifth in a civil trial, the jury can infer guilt. But here the issue is about what witness credibility. Yeah, and I think this is the bittersweet truth. Ms. K. Grift says, sometimes justice isn't served, it's not fair, and it sucks, but there are rules for a reason. Yeah, Law and Crime still has the same update. Would you guys prefer to do a part 2 stream? Like, and I'll be watching, so as soon as they come back, I would fire up another stream. Like, I'd be sitting here on my toes. So, maybe like 30-second delay, because I gotta click some buttons and make sure everything's working right. But as soon as I see them come back, I could fire up another stream. Totally your call. It seems like they take their lunch breaks at 1 o'clock. So the reason I'm thinking maybe we'll do a 2-part stream is if they do jury selection for much longer, they're going to want to take a lunch. And then we'd have nothing to do until they come back anyway. So let's see. Yeah, nothing in the NBC 10 chat either. Yeah, I think we'll do that, guys. So it was very cool. Thank you guys for being so open to the play call changing here. We're calling audibles. We're watching the pretrial hearing. I thought that was interesting to watch. In some cases that we watch over here on this channel, we do the deep dive before trial starts, right? Courtney Clenny is one of those examples. Courtney Clenny is going to be difficult for me to watch as a juror because I've seen so much of the case background. We've gone through her journal notes, like things that I don't think are going to be admissible at trial. So when that trial finally kicks off, I'm going to have to remind myself as we go through it, like, hey, the jury hasn't seen this other thing. Maybe they won't even see it. Maybe they just haven't seen it yet. Maybe it'll come in later. And so I'm going to have to like be very self-aware when we watch that. Whereas with this one, we didn't do much of a pretrial deep dive, except for going back and watching that pretrial hearing. And I always think it's cool to see what are these motions. They were working out some quirks with the jury questions that we then got to see get asked. But yeah, so thanks for being amenable to changes of plans here, you guys. Hit the bell, right? So subscribe and hit the bell, and when it pops up, it's going to give you an option to do all notifications. You can turn off the bell when this trial's done, but I recommend putting on all notifications because if you leave it personalized, it's just not going to send you notifications when we go back live later. So we'll do that, and I'll fire up a live as soon as I see a camera feed come back in. Could be 5 minutes, could be after lunch.